This is the final section of the Missouri License Practice Test. Video 7 begins right now.
Number 132. When can an individual transact insurance business without a license? A. When the individual is soliciting insurance over the telephone. B. After completing pre-licensing education requirements. C. Never. D. When the individual is licensed as an insurance adjuster.
The answer is never. You must be licensed to transact business in this state.
Number 133. An order by the Director of Insurance requiring a producer to refrain from engaging in a prohibited business practice is known as A. Subpoena. B. Cease and desist. C. Prohibitive order. D. Certificate of authority.
The Director of Insurance can issue a cease and desist ordering you to refrain from engaging in any prohibited business activity or practice.
Number 134. When a producer, agent, or broker makes a false statement about the benefits or nature of an insurance policy, A. The person is guilty of twisting. B. The person is guilty of misrepresentation. C. The person is guilty of defamation. D. The person is guilty of intimidation.
This is answer B, misrepresentation. Misrepresentation is making any false statements that misrepresent the benefits or true nature of an insurance policy, and that again is known as misrepresentation.
Number 135. The Commissioner may deny, suspend, or revoke a producer's license for any of the following reasons except A. Violating any state insurance law. B. Misrepresenting a statement in the license application. C. Unauthorized borrowing of funds belonging to insurers or policyholders. D. Being ticketed for a moving violation.
You will see a question set up a lot like this on the test. They're going to say all of the following are true except, or we can do all of these except. So this is another example of that, and what you want to do is make sure that you look specifically for the word except because it completely changes the question. The answer is D. Minor traffic tickets are not a cause for license denial, suspension, or revocation. But all of the previous three are reasons. So that's where the word except becomes so keenly important.
Number 136. The insurance commissioner may examine the records of an insurer in order to A. Determine the insurer's solvency, B. Assess the insurer's value on behalf of prospective investors, C. Approve the claims record of the insurer, D. Determine the trust deposits of the insurer.
This is a good question. The insurance commissioner may examine the records of an insurer in order to determine the insurer's solvency. The Director of Insurance or the Department of Insurance has the right to do that. We'll do that at a minimum of at least once every 5 years, but can do it solely at their discretion anytime, and any costs that are incurred by the Director of Insurance to do that examination are going to be borne by the insurance company that's being examined.
Number 137. A person who makes derogatory statements about a person engaged in the insurance business with the intent of causing injury is guilty of A. Defamation, B. Commingling, C. Rebating, D. Discrimination.
Anytime you make any statements that are designed to cause injury to another party, you are going to be guilty of defamation. A person is guilty of defamation when they make derogatory statements about a person engaged in the insurance business with the intent to harm. So if you ever see the words with the intent of causing injury or the intent to harm, that's typically going to be in reference to defamation.
Number 138. Which of the following acts is an example of a producer violating his or her fiduciary responsibilities? A. Spending premium funds from policy owners for personal use. B. Keeping separate records for each policy owner. C. Accepting premium funds from policy owners rather than advising policy owners to pay the insurance company directly. D. Promptly submitting all premiums paid by the policy owner to the insurer.
You may or may not see the word fiduciary on the test, but basically when you're an insurance agent, you have a fiduciary responsibility to act in the best interest and to protect your client. So spending premium funds from policy owners for personal use would definitely be an example of a violation of your fiduciary responsibilities.
Number 139. A cease and desist order. A is issued by an insurer when a policy owner files 3 claims in a calendar year. B is issued by an insurance producer when a claimant is suspected of fraud. C is issued by the insurance commissioner when it is in the public's best interest. D is issued by the insurance commissioner when a surplus lines broker places business with an unauthorized insurer.
You may see the word insurance commissioner mixed and replaced by director of insurance. So you could see a combination of those two different terms on the test. But a cease and desist order is issued by the insurance commissioner or the director of insurance when it is in the public's best interest. Again, when you look at the question, you're going to see things that make more sense than others. And in this case, there are a couple of these that could potentially be right, borderline, but the best possible right answer is C. Is issued by the insurance commissioner when it's in the public's best interest.
Number 140. Which of the following is not one of the duties of the Director of Insurance? A. Issue cease and desist orders. B. Implement insurance rules and regulations. C. Conduct investigations. D. Pass new insurance laws.
This is a great question because throughout this test we've said that the director of insurance can do whatever they want whenever they want. But the one thing they can't do is change the actual law. They cannot pass laws. There's a different governing body that passes all the laws. But they can implement insurance rules and regulations. They can conduct investigations. They can issue cease and desist orders. They can do pretty much anything they want. What they can't do is sign something into law, which is D.
Number 141. Which of the following may be the result of any producer, agent, or broker who knowingly violates an unfair trade practice? A. There is no penalty for violating an unfair trade practice if a specific statute was not violated. B. Their license will be revoked without recourse. C. Any company with whom they have an agency agreement contract with will be fined. D. They may have their license revoked.
Again, there's a lot of general things that we can take from these study guides, the summary of the study guide, and this practice test, and that's that if you violate any of the laws knowingly, any of the license laws, rules, or regulations, that you may have your license revoked or suspended. The answer to this question is D.
Number 142. An insurer is guilty of which of the following if they charge a higher rate for insurance based on an insured's race, religion, or national origin? A. Misrepresentation. B. Discrimination. C. Commingling. D. Rebating.
You cannot change the rules based on an insured's race, religion, or national origin. Doing so is an act of discrimination. That includes charging a higher rate for insurance based on an insurer's race, religion, or marital status. The answer is B.
Number 143. All of the following are considered an insurance transaction except A. Accepting premiums, B. Soliciting applications, C. Delivering policies, D. Dispensing materials.
These are the same questions asked different ways. The answer is dispensing materials. It is not considered an insurance transaction to hand somebody pre-printed materials or set appointments. But when you deliver policies, solicit applications, accept premiums, you are transacting business.
Number 144. Submitting a false or fraudulent claim statement, A. is illegal in all states. B. would be considered a minor infraction. C. would result in reduced coverage. D. is overlooked by most insurance companies.
Anytime you're submitting false information, that is illegal in all 50 states. It's fraud. So submitting a false or fraudulent claim statement is illegal in every state and would result in a denial of the claim. The answer is A.
Number 145. The purpose of a certificate of authority is A. To give a producer the authority to represent a certain insurer. B. Allows producers to transact business. C. Permit a deceased producer's relative to act for the producer. D. Permit an insurance company to transact business.
The certificate of authority's sole purpose is to permit an insurance company to transact business in a given state. The answer is D.
Number 146. After passing the Missouri Prepaid Legal Insurance exam, you have how long to apply for your license before you will be required to retake and pass the examination? A. 30 days. B. 90 days. C. 1 year. D. There is not currently a time requirement for license application under RSMO Section 379.901 for the prepaid legal license.
The answer to the question is C. After passing the Missouri license exam, you have exactly 1 year to apply for a license, or you're going to be required to retake and repass the examination. A lot of times, taking a look at the answers here, you're going to see one lengthy, wordy answer that when you read it looks very good, but that could be a distractor. And in the taking the test tips video that's on our passMOtest.com website, you will see that distractors are a common part of the test. Congratulations on completing the Missouri License Practice Test video series. Good luck on your test and your Legal Shield career.